Preliminary examination in person, October 21st, 2025, 9 a.m. That's before judge, before me. Bond will continue.
Thank you, Your Honor. I'll come and see.
Court does call the case People versus Plea Williams.
Good morning, Your Honor. Ed Rodriguez for Plea Williams.
Your name?
Hi, Plea Williams.
Thank you.
Your Honor, there's some additional discussions that I'm working to try and get a plea in this case. So I'm asking for a 2-week adjournment.
Probable cause conference, October 23rd, 2025, 9 a.m. without objection. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Donald. Is it Grandal?
And was in on behalf of the Your Honor.
Good morning, I'm Rob Cool. Judge, I'm on case 25-5603. State your name.
Donald Howard Grandall II.
Vaughn Brown, Deputy Public Defender, also appearing on behalf of Mr. Grandall.
Judge, I met with Mr. Grandall last night at the jail. We went over to the discovery. He would like to proceed with a preliminary exam in this matter.
What are we doing on yours?
We would likewise set down matter for preliminary examination.
And discovery is complete on yours also.
Best of our knowledge.
Yes, Your Honor.
People have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person will be set October 21st, 2025, 9 a.m. That is before Judge Moore. Bond will continue in these cases.
Thank you, Ron.
Okay. Yeah. Court calls case of the People versus. Why is this one?
Oh, I apologize. This one.
Court calls case of the People versus Erica Reed.
People.
Good morning, Your Honor. Sheila Sass on behalf of Erica Reed. Erica, please speak your name to the court of this trial.
Ms. Reed,
Yes.
state your name, please.
Erica Reed.
All right. What are we doing?
Your Honor, I'm only waiting for one document, but I do have videos. I believe all of them. So I would like to set it for a preliminary exam.
You said all discovery is complete. You were breaking up there.
I have all videos, I believe. There's just one document I'm waiting for that Ms.
She said that she sent requested.
Sounded like the clown at the drive-thru. I didn't hear a word you said. No, you're muffled on your microphone.
Yes, Your Honor. Set it for a preliminary exam.
All right. I just want to make sure that discovery is there.
There was one outstanding piece, Your Honor. The defense counsel has wanted something related to the photo lineup. I was able to get that, but it hasn't been disclosed yet, so I'll get that for recording exam.
Very good. And the people would have their witnesses available the 21st.
We will try for that date, Your Honor. Thank you.
Preliminary examination in person, October 21st, 2025, 9 a.m. That's before me.
Okay.
Bond continued.
Thank you.
Thank you. Court calls the case People versus Dominic Kelly Payne.
I spelled this for the people.
Ready on Rob Cool on behalf of Mr. Dominic Payne. Dominic, would you state your name?
Dominic Kelly.
Judge, I met with Mr. Payne last night. I was going to ask for an adjournment to get the discovery because I was just appointed late yesterday afternoon. Mr. Bellinger from the PD's office told me that he has referred Mr. Payne to the recovery court, Judge Kuhnke's recovery court, which he's already in. So at this point, I'll leave it to your discretion. I either adjourn this out a couple weeks or we wait to see if he's accepted into the recovery court, which he should be.
He's already in. You're just looking whether or not they'll take this case in.
Right. Before I was appointed, Mr. Bellinger sent the paperwork in for him to add this case to his recovery program.
Okay. Well, it would seem to make sense to put it out, see if this case goes along with it.
Correct. Plus, I can get the discovery.
So I'll adjourn it to October 23rd. Hopefully they'll have an answer, but then 2025, 9 a.m. Bond continued.
Thanks. All right, thank you. Take care. I'll be back.
Thank you.
Okay. Thank you, Judge.
Court calls the case of the People versus James Abbott.
Ready.
Jacob Kennedy for the people, Your Honor.
Vaughn Brown, Deputy Defender being written on behalf of Mr. Abbott. Mr. Abbott, state your name for the record, please.
James Brian Abbott.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. My client wishes to waive his right to preliminary examination and agrees to be bound over to circuit court.
Sir, is that correct?
Yes.
All right, you understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Brown.
Your Honor, we acknowledge receipt of the information. We waive its reading on the record. My client will enter a plea of not guilty at this time.
And then having waived formal reading, pleading not guilty, court will enter that plea. Pretrial will be set for
December 4th at 1:30 for the judge's closing.
December 4th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond will continue. Thank you. Yes. Court calls the case People versus Jamal Jones.
Assistant Prosecuting Attorney on behalf of the people.
Where's Burgess?
When somebody went up here.
Oh, looks like Burgess. That's not him.
That's Mr. Bridges, so Mr. I'm sure I'm always.
They sent you to see it?
I didn't, I sent myself, I'm trying to do it.
Oh, joy. Was he here today? Is it?
He was here this morning, Your Honor. I saw him. He was here.
He's in that meeting.
He's not,
He's not there.
He's what?
he was in one of the meeting rooms on the side of Your Honor's court. He is not there currently.
I'll have to pass that to him. Thank you.
Thank you.
Court does call the case of the People versus Tanisha Akins.
Good morning, Your Honor.
As most people.
Can you please state your name for the record? Tanisha Akins.
Thank you.
Your Honor, we are going
Did you say to your parents?
Oh, Carmen Adish on behalf of Ms. Akins. I only said good morning.
I know. I realize that. All right, what are we doing?
We are going to be asking for an adjournment, Your Honor. We have the restitution amount from prosecution. I believe Ms. Akins needs some time to be able to pay that off. So we are going to be asking for an adjournment, perhaps a couple of weeks out, if Your Honor would be.
How long?
Couple of weeks out, or as long as Your Honor finds fitting.
It's about $2,700, Your Honor.
How much?
$2,700.
She's a.
Is she going to pay that into the court?
Sorry?
Is she paying it to the court?
I believe so.
Is she going to, we're going to need an order if there isn't one for her to pay that.
Yes, Your Honor.
All right. She's going to have 2,700 in a couple weeks?
She has 90 days.
I'm sorry?
We're adjourning it a couple of weeks to see where she's at in a couple of weeks. Your Honor, she is a single mother. She does have potentially some family that she could ask for. She's certain that she can get that amount. It's just a matter of time.
Okay, so all I'm trying to figure out is how much time does she need? You're saying 90 days. You want me to adjourn it out 2 weeks?
Well, I
Make up my mind.
If you can adjourn it 90 days,
I can do whatever I want to do, but I'm just saying.
Exactly.
I may not do it, but.
Right. Well, ideally as 90 days, but if Your Honor.
I do. Just give me an answer.
1 month, Your Honor.
How much?
1 month.
Ma'am, how much time? You need 90 days?
Yes.
Okay, are you going to be placing some of the money in that period in time?
Yes.
So let's say in about a month or so, how much can you have in?
Maybe like 1,200, 1,500.
Okay, thank you. Your answers are much clearer than that person's. I now know where to kind of go. Objection. I'll need that order. I'll adjourn it to November 13th. Then we'll do a check in and maybe we'll give you some more time, but I need to see the funds, which you can get there, okay? November 13th, 2025, 9 a.m.
Thank you so much, Your Honor.
Ms. Atkins, you're welcome.
Thank you.
Court does call the case. People versus Kayla Burrell.
Baird.
Baird? Okay, I see.
Assistant Public Defender, Chinazi Carey, your Honor, on behalf of Ms. Kayla Baird.
They're gonna write the names. They need that. Yeah. And not separate like the bottom part of the deed from the other. Anyway, it's weird.
Assistant Public Defender.
No, I figured you want me just to wait because I have nothing else to do. No, go ahead.
Assistant Public Defender, Chinazi Carey, your Honor, on behalf of Ms. Kayla Baird. Kayla, state your name for the record, please.
All right, what are we doing?
Your Honor, the court should be in receipt of a plea form as well as a police report in anticipation of a no contest plea.
Did I not? I don't have the form. I have the report, reviewed the report, but I don't have a form saying what she's pleading to.
I apologize, Your Honor. I thought I forwarded it.
Oh, did you?
Yeah.
No, I'll wait.
Your Honor, Ms. Baird will be entering a no contest plea to an added count 3 of larceny 200 or more, but less than $1,000. The PAC code for that is 750.3564A.
I don't know why she. You have any idea? No. You're telling me all that?
Report right now, Your Honor.
Pardon?
I am, I don't know, should I print it or just send a copy? The people did send me the form. I thought that I forwarded it to the court's attention on yesterday. Clearly I didn't. I apologize.
I really don't want to take her back.
Okay.
Transport guys are working really hard and you guys are making it difficult on that.
Sorry.
She's never sincere. Don't listen to her. So what is she pleading to?
Larceny 200 to 1,000, Judge.
Did you send the form?
Yes, I have.
She's pleading to larceny 200 to 1,000 and that
$220 restitution.
$220 restitution. Anything else?
I think that's it.
That is
The
it.
original counsel be dismissed.
So that's the added count 3 that she's pleading
That's
to.
correct.
And then that she has it all worked out, Ms. Akinruli. May I have her sworn, Mr. Allen?
Do you solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the truth? You got it. State your name.
Did she sign an advice of rights form? Well, she has to know her rights.
Yeah.
I'm gonna pass it.
Okay.
Sorry, Ms. Smith.
We did discuss them.
We'll
Your
get you
Honor.
back out. We'll have the form. Everything will be in order and we'll be able to go ahead. No, good job, Chinaza. We've done 8 cases by the time we did nothing. Court calls the case People versus, is it Haitham Shalabi?
Jacob County, particular honor.
I probably messed that up, but I did what I could.
Assistant Public Defender Hannah Apple standing in for Mr. Feaster today on behalf of Mr. Al Shalbi. We say your name for the record.
Haitham Al-Shalabi.
I wasn't.
Your Honor, we are going to ask for an adjournment. I did discuss this with my client. That is what Mr. Feaster's request is today. There's some additional information to discuss with him.
All right. Probable cause conference will be adjourned October 30th, 2025, 9 a.m. Bond will continue.
Thank you.
All right, thank you. Thank you. Court calls case People versus Johnny Bankhead Williams.
And on behalf of the people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bankhead Williams, who's approaching. We say your name for the record.
Johnny Bankhead Williams. Thank you.
Your Honor, we're asking this matter be set for preliminary exam.
Discovery is complete.
To our knowledge, yes.
We'll have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person will be set October 21st, 2025, 9 a.m. before Judge Moore. And will continue. Thank you. Court does call the case of the People versus Kamani Barfield.
And on behalf of the people, Your Honor.
One round Deputy Chief Public Defender have been written on behalf of Ms. Barfield, who approaches.
Your name?
For the record.
Kimani Barfield.
Thank you.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is complete.
Best of our knowledge.
People have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person will be set October 21st, 2025, 9 a.m. That's before me. Bond continued.
Thank you.
Thank you. Court calls case of the people versus Brandon Beliski.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bill, approaching now. Mr. Bilski, will you state your name for the record?
Brandon Travis Bilski.
All right. I have before we, is that what we're doing?
Yes, Judge, and he is executing his advice of rights form.
Thank you. All right, the plea form indicates that the defendant will be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon a successful plea to that count 2, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Brandon Travis Bilski.
Sir, it is this court's understanding that you can put your hand down, that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Is that correct?
Yes, it is.
It's understanding that you still wish to plead guilty
Yes, it is.
to that charge. How do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, I do.
You signed an advice of rights form. Is that correct? Any question regarding any of those rights?
No, there is not.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, they haven't.
You're doing this voluntarily
Yes, I am.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of March 15th, 2022, at the location of Carpenter Road near 3825 at the Myers Store, Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, I did.
Had you used it?
Yes, I did.
Did you know what you were using was methamphetamine?
I did know what I was using.
Sir, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, the court would no longer be bound by any sentence evaluation in this case, and you would not be entitled to withdraw your plea. You understand that?
I do understand.
Counsel, has there been any other promises, threats, or other inducements which have led to this plea?
Not to my knowledge.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, the people.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
October 22nd at 12 p.m.
October 22nd, 2025, 12 noon. That's before me. We'll continue.
Thank you.
Thank you. Court calls case People versus Anitha Barnes.
Councilman Water, Assistant Prosecuting Attorney, on behalf of the people. This is Mr. Carey.
I know. Ms. Barnes?
Made by Mr. Brown.
Anitha Barnes.
All right, thank you, ma'am. There, she's gonna saunter up. She is in no hurry.
Judge, if I move faster,
Then what will happen? You'll fall? Cool.
Yes.
So,
The public defender, Shanazi K. I can move with Your Honor. On behalf of Ms. Anitha Barnes, Your Honor, we're requesting an adjournment in this matter.
purpose of the adjournment, what's
We did receive an offer from the people. She
Got it.
needed some time to
process?
stew it over. Yes,
All
Your
right.
Honor.
October 30th, 2025, 9 a.m. And while we were waiting your arrival, your client did state her name.
Thank you.
Don't have to worry about that. Thank you, Ms. Barnes.
Thank you.
Court does call the case, People versus Jeffrey, is it Butchinger?
Jacob Kenny for the people, Your Honor.
And Stephanie Can on behalf of Mr. Buckinger, who's proposed change. The court, your name, please.
Jeff Buhinger.
Buhinger, I was wrong. Your Honor, we are asking for an adjournment for plea negotiation purposes in this matter.
That objection, probable cause conference will be adjourned October 23rd, 2025, 9 a.m.
We approach this briefly.
Record should reflect we had a brief bench conference in this case. I will adjourn this matter to November 13th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case, People versus Crystal Barnes. It's a request for an adjournment.
Stephanie Cannon on behalf of Ms. Barnes, Your Honor.
I think it's a request. Well, no, I'm sorry. Hang on. It's okay, man. State your name, please. Ms. Barnes.
Crystal Barnes.
Thank you.
You're welcome.
I'm ready. Warren Brown, Deputy Chief Public Defender, opinion with and on behalf of Ms. Barnes. So today is the date and time set for the probable cause conference. We requested an offer in this matter. There's no offer made. We will set this matter for preliminary examination.
All discovery is complete.
Best of our knowledge.
People would have their witnesses available the 21st.
I believe so.
Preliminary examination in this matter will be set October 21st, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you very much.
Thank you, ma'am.
Thank you.
Let's call the case, People versus Jason Campbell.
Kenneth Overwater, Assistant Prosecuting Attorney on behalf of the people.
And Kerma Dadush on behalf of Mr. Campbell, who is next to me. Please state your name for the record.
Jason Brett Campbell.
What are we doing?
Your Honor, we're asking for an adjournment and a moment to address the bond case. I believe we still have.
Reason for the
discovery.
adjournment.
We don't have discovery on this case yet.
Is that coming over soon
Yes, Your Honor.
to them?
Yes, Your Honor. It has to go ready.
Probable cause conference, October 23rd, 2025, 9 a.m. as to bond.
Your Honor, we are just stating for the record, we're not necessarily requesting anything today. We are going to be submitting.
Then why are you talking?
For the record.
No, go ahead. Fine.
We're going to be submitting hopefully a proposed order to get him released into treatment. He does have a.
That's fine. You can submit the order. As I've always indicated, if it's a release to treatment, I will be more than happy to sign off.
Yes, the reason I'm sitting on the record is because he does have a wing.
What makes a judge lose patience with a defendant? In this courtroom, the answer becomes clear. Austin Miller is back before the court on a probation violation, and this isn't his first warning. According to probation officers, he was arrested after allegedly violating a court-ordered no-contact condition, one of the most important rules imposed in cases involving personal disputes. Prosecutors argue that the violations didn't stop there, claiming continued communication through texts, emails, and other messages even after his release. The defense points to progress. Miller says he's attending therapy, participating in treatment programs, maintaining sobriety, holding a full-time job, and trying to rebuild relationships with his family. On paper, it looks like someone making positive changes. But in court, compliance isn't measured by good intentions alone. Judges often focus on one key question. Did the defendant follow the court's orders? As the hearing unfolds, the judge begins examining not just what happened, but why it happened. And what follows may determine whether months of progress are enough to outweigh repeated violations of the court's trust. This is the turning point of the hearing. Notice what the judge keeps returning to: accountability. The defense argues that the alleged victim initiated contact repeatedly before Miller responded. from a personal perspective, some viewers may understand the temptation to reply, but legally, that's not usually how no-contact orders work. In many cases, the responsibility remains on the restricted individual to avoid communication entirely, regardless of who reaches out first. That's why the judge appears focused less on excuses and more on decision-making. The court has already given opportunities, supervision, treatment, and probation. Yet the concern being expressed here is that Miller continues to make choices based on his own judgment instead of strictly following court directives. And that's the question hanging over this courtroom right now. Should rehabilitation efforts outweigh repeated rule violations? Or does ignoring court orders erase the progress that has been made elsewhere?